already started?
Good afternoon.
Good afternoon.
Mr Nauth, would you like to start proceedings?
Thank you, Madam. I am Imran Nauth, I'm Solicitor for Bob Smith, and may I equally present to you my colleague, Fiaz Ranzeb,
Thank you.
representing Dave Rock, trading as Rocky Constructions Limited. Respected Madam, I'm making a perfectly valid and legal submission on behalf of my client for personal injuries claims and PSLA, pain, suffering, and loss of amenities, and my client will defend contributory negligence. Madam, I will refer to these two claims as PI and PSLA henceforth. I am making this submission in the hope that you may find a favorable solution for my client. I would like to take this opportunity to present the facts of this case. In brief, on the 5th of August 2018, my client was working on the Bradford building site with the Rocky Construction. At approximately 10 a.m., while he was working on the scaffolding, suddenly the scaffold started shaking. He thought that he saw someone but could not recognize this person due to the weather condition. My client fell from the scaffolding a height of approximately 15 feet to the ground, feet first. He landed on his right foot, on his right side, right leg first. He then put his hand to cushion the fall with the aim of avoiding more injuries to his head. He managed to prevent extensive injury to his head, but it did come into contact with the ground. He had been joking around all morning with Danny Digger and Jim Shovel, who are two of his work colleagues. They have been play fighting, and Mr. Rock, the owner of Rocky Construction, had seen them on the morning of this event, fooling around. According to these policies of Rocky Construction, it is generally accepted that this company encourage practical jokes and play fights, and they claim it is good for team morale. As a result of the fall, my client suffered the following injuries: fracture to the wrist, which was put into plaster by the hospital for a month, a deep laceration to the forehead, which required 10 stitches, and which will leave a permanent scar, metatarsal fracture and ruptured ligaments in the right foot with the risk of future complications, significant fracture to the right femur, that is the upper leg bone, which is likely to have permanent effect. He could not remember the full details of all the event when he fell, because he was unconscious for a while, and then Mr. Rock had called the ambulance. As a result of this injury, he was hospitalized. He was in the Bradford Royal Infirmary Hospital for 3 weeks. He suffered from headaches for a week, and he still suffers from nightmares and flashbacks of the incident, and had a fear of height, and he has a fear of heights and working on scaffolding. Madam, other losses other than PSLA and PI would include the loss of earnings. We have a credible witness, a fellow employee, Mr. Donald Spade, who saw the incident on the morning when it occurred, and is prepared to act as a witness should you require more clarity on this matter. After taken instructions from my client and consulted with my principal, we are claiming for the following injuries and the sum. Laceration to the forehead, number 1, we are looking to claim £42,000. And the reason for this is we use the case of Woodbourne versus Liverpool Council, City Council, Queensbend Division, and this was a head injuries, and there's elements of permanent scars. We are looking to claim $42,000 because of this permanent scars which will be on my client's head for life. Fracture to the right wrist, we're looking to claim £5,000. Metatarsal fracture and ruptured ligaments in the right foot, we're looking for $10,000. And for the fracture to the wrist, we're using the authority of Curtis versus London Underground Limited, and he was awarded $13,000, and we're looking only for $5,000. In the metatarsal fracture, the case of Lane and Tolman Automotive Limited, where he was awarded $58,000, and we are looking for $10,000. A fracture to the right femur, we're looking for $10,000. And the case of Clements versus Wake, he was awarded $8,000. Psychiatric flashbacks, we're looking for $10,000, and our authority for this is P. Lancashire and Yates Wine Lodges Limited. My honorable friend, madam, will argue contributory negligence, but frankly, we are not in a position to discuss this matter further. Our main aim is the rattling of the scaffold which caused the injuries to my client. Whether it's Danny Digger or the Digger of Danny, or whether it's another person, we are not concerned with this. Our main focus today is that this was done by one of the employees of Rocky Construction during the course of his employment. Therefore, we see Mr. Dave Rock, who is the owner of Rocky Construction, they have a number of flawed policies which puts the workers at tremendous risks. David Rock's census action is an indication of his indirect and oblique intentions for negligence. We find Madam Dave Rock had a duty of care to my client. He had to make sure that he provide these equipments. He has breached this duty of care when he did not put measures in place.
Was the equipment not provided?
The equipment he provided was the helmet and the harness. But madam, my client, as you will see by the end of this presentation, that he is not to be blamed for this, which I would like to rebut this in the end, towards the end. So David Rock, is it fair and just to reasonably impose vicarious liability on the David Rock and his company? Obviously this is because they have a duty of care to workers. They have breached this duty of care. They have caused much injuries, much damages, and like I said, it's a civil wrong done by one of the employee, and she should be more sensible when dealing with the employees. At this point, I would like to take my seat.
May I approach the bench? Good afternoon, madam. My name is Fiaz Ranzeb, and I'm representing Dave Rock, the defendant in this matter, on behalf of Cogger Leggett Solicitors, and we are based in Belgravia in London. Madam, as my friend opposite has already explained, circumstances of this case arise out of the events that occurred on the 5th of August in 2018 at a building site on Bradford Road. The works there were contracted to Rocky Constructions Limited, owned by my client Dave Rock. My client has owned and run this company for over 20 years. He has a loving wife and 3 fantastic children. The company is his one and only business and his only source of income, and the source of income for some 50 more employees and their families also. The employees there describe him to me as a friend and a father rather than their boss. And I think this, at least to me, shows the love and the care he takes towards his employees and towards his work. Madam, in the 20 years of operation of Rocky Constructions, there has not been a single instance or a single accident, reputed or otherwise. This construction company is highly professional and has an impressive and impeccable safety track record. Madam, it has always been our position, and I do empathise with the pain that the claimant and his family have suffered. It has always been, and still is, our position that this was merely an unfortunate accident. My client has taken full due care in the operation and the day-to-day business he runs with himself and his team. He has provided ample and adequate safety equipment for all of his employees, including hard hats and essential body harnesses to prevent such falls from happening. He has noticed on a few occasions that the claimant has deliberately not worn his safety equipment and has reasonably held him to account by way of stern warnings in the past. Madam, the weather on this particular day was wet and windy, and I think it's safe for one to assume that the scaffolding and the platform on that day was also wet and slippery. Mr. Smith took it upon himself that unfortunate day to climb the scaffold without safety equipment whatsoever. And in the absence of any CCTV, in the absence of any eyewitness to the actual fall itself, and our rebuttal of Mr. Donald Spade's statement with our witness statement contradicting the events of that day, it is our position that the claimant has slipped and fallen to the ground. Unless my friend opposite can provide any evidence on the contrary to reasonably suggest that an employee through their negligence had caused or put into motion a chain of events that led to the fall of Mr. Smith, then it would be wholly wrong for the court to find my client had breached any duty of care that was incumbent upon him. Madam, if the court feels otherwise, then we will not be arguing vicarious liability. I think the law is set in stone when and where an employee is vicariously liable. However, we will be arguing a defence of contributory negligence, and I think that's quite rightly so, given the facts that the defendant failed to wear any personal protective equipment on that day, which we believe, and any reasonable person would, that the injuries sustained by Mr. Smith would have been drastically reduced, if any whatsoever. We are aware that the burden of proof now shifts to the defence to prove that contributory negligence is a live issue, and we intend to do just that. Madam, I beg the court to take into consideration Section 1 of the Law Reform Act 1984, which relates to the proportionality of damages awarded to claimants, and that it should be reduced accordingly as the court sees fit and proper to do so. You will find this legislation in Exhibit 1A on your desk. I'll give you a moment to read that piece of legislation. Madam, you will also find Exhibit 1B on your desk there. This is a professional medical opinion by a Dr. Chakraborty. And in his medical opinion, he summarizes, "It is my professional opinion that had the claimant been wearing a health and safety executive standardly approved EU safety regulated hard hat, the lacerations and injuries suffered would have not occurred. I am also of the opinion that the safety harness had been worn, there would have been no fall at all. And if there would have been minor grade 2 bruising to the leg and the torso area only. Madam, I will also refer to the case of Harrison and the Ministry of Defence in 1993, where the judge refers to the standard of care that's reasonably expected and that claimants must take such reasonable care to avoid such accidents. And the questions for these proceedings would be, does the court feel that the claimant fell below the standards that were required of him to take proper care? I will mention another case. To give the court an indication as to what amount, in terms of quantum, were awarded in similar cases with similar claimants suffering similar injuries with contributory negligence. In Palmer and Big Security in 2008, the judge reduced the compensation award by 30% because the claimant was found to have contributed to his own injuries. And in Woodham and Turner in 2011, the judge also reduced the amount by 30%. To summarise, madam, my client is an honest, hard-working family man whom takes proper care towards the safety of his employees. He is not a man who blatantly disregards any safety laws, especially at work where such accidents are foreseeable. It is our position that, number one, that this was merely an unfortunate accident and nothing more. And if the claimant has not met the standard of proof that's required of him on the preponderance of that evidence to suggest otherwise, then my client in those circumstances should not be held liable. Number two, if the court finds otherwise, then we would argue that Mr. Smith has contributed to his own injuries through his own negligence by failing to wear proper personal protective equipment which was provided for him. I hope my defence statement has made clear all the relevant facts and matters of law in these proceedings. If they have not, madam, I will be happy to answer any questions that the court has to facilitate one decision in this matter. Thank you kindly.
Can I just raise a question?
Yes, sure.
Mr. Ranzeb? Just in relation to the, obviously you say that the equipment was provided.
Yes.
It wasn't worn, so
Yeah.
obviously the claimant was at fault there. Besides obviously the provision of the equipment, was there anything else enforced that could have been done or should have been done?
Like I'd mentioned earlier, madam, he had taken reasonable steps to make sure that these safety equipments were worn, and in the past he had warned Mr. Smith to wear his personal protective equipment. But also I'll refer back to the statements of, just give me a second to find it.
Mm-hmm.
The statements of the judge in Harrison and the Ministry of Defence, where also there is at least a standard of care that the claimants should take in order to avoid such accidents. Any further questions?
Thank you.
Madam, I would like to bring the court's attention to some important underlying legislation regarding this matter. I would like you to consider the Health and Safety at Works Act 1974. It says health and safety takes precedence over employment. So we have seen my learned friend over here is saying his employer is a very serious man. He cares for his children, he cares for his job, he has 50 employees. But what he didn't mention is health and safety takes precedence over employment. So this would seem to me that he is only focusing on his wealth and he's not focusing on the health of his employees. Dave Rock, I believe, he has a recipe for disasters. He has a business where he has a recipe for disasters, and it's one that my learned colleague, my learned colleague over here, is fully aware of this. The Workers Act. We find that the Workers Act encourages a healthier workforce, help to manage hazards and risks, comply with legislative requirements, potentially reducing insurance premiums, increase productivity. You find that Rocky Construction is everything but these values. You find that Rocky Construction has actually provided the equipment, madam. We find a section, that's true. It's section 4 of the Protective Equipment Act 1994. He says they have provided my client, my colleague, my Mr. Bob Smith with protective equipment. A fact that is clear. We find that they to ensure the section 10 of this act says to ensure that the worker wears this. Points to note, madam, is not only does Rocky Construction should provide his duty to ensure to provide this equipment, he should also have strategies and methodology to ensure that these workers are wearing these equipments, regardless of the worker's stubbornness. And my learned colleague here will realize that in the negligence of recklessness, if a worker refuses to wear this, and the court will know that this is a sackable offense, because we look at the well-being of people. We try to eliminate as much as possible. If we have these kind of events, we find insurance premium will go up. This is a negative for this company. This company is tarnished its reputation. My learned friend also know that indeed is important, a serious matter as it relates to the Health and Safety Act of 1974. And he also knows that his refusal to wear this warrants dismissal. He will also know that his company can face prosecution in unlikely events of these nature. And this is the main reason why we are making this submission, madam. So my question to the court today is, what measures has this company, Rocky Constructions, implemented to ensure workers' safety as it relates to equipment? And the answer is none. What measure has he put in place to stop the workers messing around? Imagine this court has some workers here and everyone is messing around. This does not encourage good health work ethics. He claims to encourage good and playful teamwork. Well, on the contrary, this is not clearly the case with my client, Bob Smith, who is now suffering from these ailments. These so-called work ethics are very questionable, madam. What will be the situation if he had fallen and died? What would be the situation if he was permanently incapacitated? What would be the situation if he was paralyzed? What about if these 50 workers who were with this company, they were to, because of not having the strategies necessary to implement and ensure that these workers are wearing this equipment, what would the result be? Rocky Construction has a higher standard of care to its workers, especially the time of operation, as they are a service provider. They have breached their duty of care and made a catastrophic failure to assess this risk. They have inadequate management. Madam, money alone will not replace my client's limbs and psychological scars. To be candid, they have shocked and disappointed my client by the catalogue of errors. Madam, in the light of my submission, I hope this court will understand the gross negligence and injustices that have taken place towards my client and reward my client handsomely for all the claims presented for your consideration. And I would like to add that I've submitted my bundle on time for your consideration. Thank you.
Thank you. Okay, so after hearing both sides of the evidence, and in relation to obviously there are issues on both from the claimant and the defendant, which then raise issues of contributory negligence, which have been raised by either. In relation to the overall total that you are claiming for, okay, the overall total that you're claiming for, there will be 50-50 contributory negligence. Okay? Thank you.
Okay, thank you very much.
Quick turn off and I'll tell you why.
50 bits, not bad.
Yeah, you didn't give me a total to work on.